Michael, all yours.
So I'm going to try not to put people to sleep with one of the least interesting topics about being an entrepreneur, which is
so important.
so important. Which is, some of the foundational things you need to do to kind of keep yourself out of trouble. Now, what I would tell you is there's a lot of things you could do, and one of the things that I think lawyers don't do a great job of in advising early stage companies is they look at it and say, well, you got to do all of these things. And as we all know, that's just not the way it works, right? You can't, and frankly, I would say you shouldn't put in place absolutely everything. If you go to a lawyer, they might say to you, you absolutely have to have a 100-page employee handbook. And they're like, well, what do you mean? We only have one employee, right? So a lot of this is that you have finite resources, right? And you have to take some steps that are absolutely important to take. And hopefully I'm going to give you some insights on what those are and and good ways to go about doing them. But always when you're talking to lawyers early on, always keep in mind that their role a lot of times is to look at it from a purely legal perspective, right? And sometimes that doesn't always take into account the judgment of what it's like to be in an early stage company. Okay, so I promise I won't bastardize my ex-profession anymore, but I want you guys to keep that in mind that as you're thinking about some of these things. So let's start with some foundational things, right? If you think about early stage company stuff, some of the things that are the most important. First and foremost is actually forming a company. Many people have independent businesses where they're just doing it themselves. And in many cases, that's super easy. There's nothing wrong with doing it. But one of the big risks that you take is personal liability, right? If you're not doing this through an entity, some type of company, a corporation, an LLC, if something goes wrong, right, people go after you personally. What that means is go after you, your house, right? And so, once you're doing this at any level of at earnest, you should form a company, right? You should be forming an LLC or a C Corp. And there's last week's session, we went over a lot of this, and there's a recording in that where we went through a bunch of things around, some of the more fundamental legal issues. So I won't spend too much time there. Okay, so let's say you've gone ahead and you've formed a company. The other thing that you should absolutely be doing is you should always be keeping your personal financial stuff and your business financial stuff separately. Okay. That means separate bank accounts, right? Separate debit cards. That doesn't mean that if you go on a business trip, you can't put something on your Amex card and then get reimbursed. But you really should be keeping everything separate. It costs virtually nothing to set up a business bank account these days. And so, go to the bank where you have your existing personal accounts and ask them to set up a business account. And you might have to keep $100 in there or whatever, but sometimes a little bit more. But it's just really important to start to have those foundational things, because you just don't want to ever get in the situation where those things get really mixed up when it comes to not so much legal stuff, but definitely tax stuff. Okay, so pretty basic types of things. Okay, so now you've got an idea, you're getting into doing this. The other is basic insurance, okay? You should be able to go to any insurance broker or even go online. Certainly if you have any type of other insurance that you have for your home, your car, or whatever it may be, just some basic general liability insurance for your company. It's not particularly expensive, okay? And generally speaking, even the most basic of insurance will cover you for a couple $1 million of things that could go wrong, right? And those are things you might get sued for, and problems you may have that is especially important. Now, for certain types of businesses, this is even more important. So that's like if you run a restaurant, if you're doing any kind of manual labor, right? If you're, anything where there's kind of some physical interaction involved, this is even more important, okay? If you're a PR firm, it's important, but chances are your risks are a little bit more manageable, okay? But going out and getting a basic insurance policy from any of the major insurers just for general liability, I think is something that will keep you at least a little bit out of trouble, okay? Next, and this one's actually a little bit harder and sometimes seems unnecessary, but is really doing, and that is co-founder agreements. I cannot tell you how many times that we at The Lonely Entrepreneur, people reach out to us and say, my co-founder and I used to be best friends. My co-founder and I used to be husband and wife. My co-founder and I used to be fill in the blank. And now we can't wait to get away from each other. Uh, Starting a business is complicated. And many times there's nothing better than doing it with somebody who you know, and it can be incredibly fun and you go through the challenges together. But a lot of times it causes stresses. People are bringing certain amounts of money to the table. They're bringing certain amounts of capabilities to the table. I have a friend right now, one of my closest friends in the world, that's starting a venture with some people that he had done business before. And, we're handling this kind of negotiation because it's really hard for friends to sit down and go, you get this and I get that, and those types of things. The problem is that if you don't define, this is what you're going to put in, this is what I'm going to put in, this is the amount of time you're going to spend, this is the amount of time I'm going to spend, this is the equity I'm going to own, this is the equity that you're going to own, that inevitably, unless things go perfect, right, leads to conflict. When you do a little bit of that, it really does help to make sure that everybody's on the same page. Now, sometimes you might have to bring in a third party to help you have those discussions, because it's sometimes very difficult to have those discussions about, say to somebody who you really like and care about and you're going into this venture with, I should get more, right? It's an unnatural thing to do. So, and that doesn't have to be a lawyer. It could be a business person that that could step in and just kind of negotiate back and forth. So it can be a little bit more, a little nicer in the process. Okay. But founders agreements are not done nearly as much because they're not necessary. Setting up an entity is very necessary because of liability. Founders agreements, they're not necessary, but I'd say to you, it sets you up for foundationally, a better chance of success. Okay.
Like a couple of questions as you're talking about this. So one, somebody asked, is insurance for a career counselor necessary? And then
say that again.
Is insurance for a career counselor necessary?
So what I would say is any type of business should have basic insurance. So it doesn't really matter what service you're providing, it's just that, or product you're offering. I'll give you an example. You could be like, well, all I do is bake cookies. Well, what happens when somebody chokes on the cookie, right? So whether it's those types of services or any types of services, go get basic insurance just to have yourself a little bit covered.
Okay. And then the other question is, at which point of in the business should you think about getting insurance? Just as you're, if you just registered, if you're already running it, or is it once you start generating a certain type of revenue?
I mean, pretty much day one. It should be it's not very expensive. So it's, you should look at getting is pretty much right when you open up shop.
Gotcha, just to protect yourself. Okay.
Yeah. Cool. Okay, let's go on to a couple other areas. Again, these are things about, things where you want to protect yourself and kind of keep yourself out of trouble. Next is whenever you are working with the resources that are going to help you grow your business. So that can be employees, it can be vendors. You want to make sure that everything that they're doing, that you're paying them to do, is owned by the company. Okay? So what does that mean? That means that if you hire an employee, that you have one of two things. Number one, as part of kind of your terms and conditions of employment, right? The provisions that basically say everything you do when you work here is owned by the company. Sometimes people go a step further, which is really the right step, which is signing an agreement. And that agreement basically says all the intellectual property and everything that you do while you're here is owned by the company. That's sometimes a separate agreement, or if you actually sign an employment agreement, which is not normally what happens in earlier stage companies. I mean, normally you're not going to the point of signing an employment agreement. If you do, that provision is often in that employment agreement that says everything you do here is owned by the company. Okay. I have a situation right now where I'm advising somebody that has a patent that is coming to a company with the patent, And it turns out that the patent was developed when they were at a university. And for any of you that know anything about universities, they are notorious for, claiming rights to intellectual property. And because this wasn't buttoned up, it's all messy. Okay, so either as part of your terms and conditions, which could be in like an employee handbook, or a separate agreement, which if anybody needs one of these, we have them, or as part of an employment agreement. That also extends to 1099s and independent contractors, right? So, and again, we have these agreements as well as in the lawyering community. When you bring on somebody to do work for you of any shape or size, there should be a provision in there that basically says anything you do while you're working for us is owned by the company. Okay, super, super important because people leave, they can deal with change. Now, that's not to say that individuals that come with their own stuff, that you should own that. That's not what they're saying. They're just saying while you're here, right? Everything you do while you're here is owned by the company. Imagine, I'll use a lot of times we think of this in the context of technology business, but imagine it's like a cookie recipe, right? And somebody says, oh, this is great. So these are things that all have to be, kind of worked out. But for the most part, there are very, very simple agreements and very, very simple provisions that just get put in like an independent contractor agreement. And that applies to whether somebody's designing a logo for you, right? Whether somebody's building technology for you. You always have to build in the fact that you have complete ownership, and those provisions can be somewhat extensive. They can say not only do you have ownership, they have to help you file anything you wanted to file around trademarks or patents, right? So it's really necessary to make sure that you're doing that stuff for all the resources that you bring in to help. That should even be in your advisory board agreement and your board of directors. I mean, board of directors don't usually sign agreements, but like sometimes you'll have an advisor agreement. In that advisor agreement, it should say everything that's done on behalf of the company is owned by that company. Okay. V, was there a question?
No, Nicole was just asking, should you do that with the contractors and to get them to sign up that everything's owned by the company, but you answered that. So
100%. And in these independent contractor agreements, there should be a provision there that basically says that.
Yep.
Okay.
Perfect.
I'll take that just a little bit step further since we're talking about it. Is one of the other things that should happen when it comes to contractors, especially people that you're paying a good amount to, is other restrictions that those contractors might have. And this can also apply to employees. And they often call these kind of non-competes, right? So if you come do work for our company, you shouldn't be able to go do work for a competitor. Okay. Now, if you bring someone in and you pay them $4, nobody should sign an agreement that said they shouldn't go work for a competitor. That's not what I'm talking about. What I'm talking about is if somebody comes in and does something meaningful for you, such as build a product, right? Or really develop something that is going to be proprietary. It's perfectly reasonable to ask that they do two things. Number one, they don't compete with you for a period of time. Let's say it's a year. So if you said, okay, we're a cookie maker and you're going to come here and you're going to work and we're going to pay you $50,000, you shouldn't be able to go work for another cookie maker for a year. Okay. Now, if you pay them a very little amount of money, it's very reasonable for somebody to come back and say, listen, I'm in the cookie business. I can't not go talk to other cookie makers. So there's a balance to this. Okay.
Yeah, and I think that was David's question is how practical is it to enforce these agreements?
Well, I think that every state is a little bit different, and I think the more, there's some states that are kind of absolute on both sides. Some states take the view that these should never be enforceable. Other states take the view that they're very enforceable. Here's what I would say: the key to them is being reasonable. In one sense, we're trying to balance that. We don't want to restrict people's ability to work as a kind of a public policy. But on the other hand, people are doing things where they get proprietary information and things like that. So what does reasonable mean? It's generally two things. It's time and scope. So time being a shorter period of time. So it's hard to get long-term non-competes enforced unless there's a lot of money involved. So generally speaking, a year is considered reasonable. 2 sometimes is a stretch. And the second thing is scope. If you say, you can't work anywhere anyhow, that's hard. But if you restricted them to a couple of named competitors, right? If you actually said you can't work for these 5 specific companies, that's usually reasonable. You could say it's only in this industry, that's broader. And it also could be limited to geography. You could say only in the United States or only in Tennessee. So what I would say is this, is even in states where there's a predisposal for them not being enforceable, I would still have these provisions in your agreements and deal with them what they will. Because if somebody is really doing something proprietary for you, then you should put them in your agreements. Now, even if they're not enforceable, the provisions in these agreements that relate to confidentiality, there's separate provisions that say anything that you learned that was confidential here, you can't use in other places. Those are enforceable everywhere. So this is not mutually exclusive about these particular non-competes, but suffice it to say that people that you're bringing in that are your senior management, key leaders, key vendors, or personnel, you should be asking that they agree not to work, especially if you're paying them a meaningful amount of that not to work for competitors, even if it's limited to a couple competitors that you name. Okay, and it's perfectly reasonable also to have them represent in their agreements that they don't currently work for any competitors or to disclose any places that they already do.
Okay, so we have a couple of questions. As far as these agreements go, are they for nonprofit? And this is when I typically hear the quote unquote board.
I'm sorry, V, one more time.
As far as these agreements go, are they for nonprofit? And then Natalie was just saying this is when typically hears the word board, right? This is a board kind of a.
Nonprofit is an entity just like any other entity. So this is for profits, nonprofits, the same exists. Obviously, it's a little more prevalent in the for-profit arena, but no, I mean, nonprofits do things all the time that it's perfectly reasonable to. A nonprofit is really just
agreements in the nonprofit too.
What's that?
To use these agreements in a nonprofit.
Yeah. A nonprofit is just an entity that has a special tax status. So it's just like any other company. So yes, these should be used in nonprofits as well.
Okay, now what about if the contractors international, like through Upwork, would these fold up?
You absolutely should have these provisions in any relationship you have with anybody anywhere. Now, when you actually go to enforce them, if you have somebody that is in Bangladesh, and a lot of your agreements should say, this is governed by the laws of the state of wherever you are. It's just that it would hold up here. It's just a matter of what can you do to somebody that's halfway across the world. So the fact that they would hold up or not hold up shouldn't prevent you from putting them in your agreements. It's just that you have to realize that how do you actually enforce them legally? You might win a lawsuit, but then you say, okay, you have a judgment against somebody that's halfway around the world. How does that actually get actualized? And that can be very expensive to do. So a practical consideration, but you should definitely still have them in your agreements.
Perfect.
Cool.
Good.
Great. So I think that, some of the things that I'm talking about from a protection perspective are you can probably tell, like, they're foundational, right? It's like set up the right entity, set up the right bank accounts, get basic insurance, make sure the people that are working for your company that you own all your stuff, whether it's be contractors, employees, or, whatever it may be. And those are the types of things that if you don't get that stuff right, including the founders agreement, right? If you don't get the stuff right about who really owns what and the relationship, that when you go out to do, when your vision starts to come to life and you want to raise money, for example, that gets all really messy. If it's not, it's all clear and it's clear, kind of who owns what. Okay. So let's move on a little bit to to customers.
Michael, sorry, can I ask you one? There's another question that came in. Are there any policies you can put in place to protect your employees?
To protect your employees?
Yeah, should you put policies to protect employees?
When you say, are you saying protect them or protect the company from them? Like, can somebody, whoever asked the question?
Protect the employees. In other words, should a company have an agreement that would protect employees as well as the company? You know what I mean? So it's both ways.
I mean, generally speaking, the company is not putting in place policies to protect the employee. Usually it's trying to say what's the right relationship with the employee, right?
Right. Yep.
So I think it's a little bit different. So, okay, but happy to, if somebody has more color on that, please let us know and I'll try to answer it more specifically. So now let's go on to customers, okay? Now, many times, and think about there being, consumers as customers, and think about there being businesses or organizations as customers. So let's start with consumers. With respect to consumers, like selling products through a website or things like that, what you really want to try to do a pretty good job with are your, for lack of a better word, kind of standard terms and conditions, standard privacy policies, right? And generally speaking, what most organizations do is that, on their websites, you'll have, here are the standard terms and conditions, and here are our privacy policies and other, policies like data protection and stuff like that. If you go on Facebook, there's tons of policies that says, here's what we're going to do with your data and stuff like that. So get your basic terms and conditions for your core product kind of set. And then, when people are ordering online, you kind of show it to them, or you have them in your standard menu bars or whatever it is, so that those terms and conditions are something that always protect you. We've got some samples, but also there's samples where you can, take the service that you're the closest to and go look at their website. And a lot of times they have done a good job of thinking through the issues that are very specific to that business, in which you might be able to use that as a model to put in place your own terms and conditions. The same thing is true with privacy policies. Privacy policies are such that, they're not completely generic, but many of them are generic. And they talk about using data a certain way, and data that they're going to use and not use, and obviously that's a very sticky issue these days, especially with technology companies, and especially in Europe and in other places. So it's just good to protect yourself by having kind of standard terms and conditions, even if you start with a basic one, and standard kind of privacy policy for a consumer site. With respect to, and as you know, like when somebody's ordering online, as an example, or ordering as a consumer, a lot of times, if you ever walked in a store, right, your terms and conditions are like on the back, right? It's just like, here's the terms and conditions of what you just bought. And so, from a consumer perspective, you just want to have them set, right? And even if you're operating something like within a store, you want to say something like, all the products here are subject to the terms and conditions located at, name your website. Okay. So that way you can always say, right, these are the terms and conditions under which you've purchased this product or service. Okay. When you sell something to a business, people ask all the time, should I have a contract with this business, right? Should I actually go and get a legal agreement signed with the business for what I'm doing? And the answer is, it depends, right? Many, many, many things, right, are done without contracts. When a company is contracted to go in and, clean an office, 99 times out of 100, there's no contract. There's just an invoice, and the invoice has a bunch of terms and conditions on it, right? And one of the things you can do if you're using any of the basic accounting packages, when you go to create an invoice, you can actually create terms and conditions that sit right on the back of the invoice. And so it basically says, you've gotten this service from us, and it's subject to these term conditions. That's the way most products or services are bought on the planet, is without any type of agreement with your customer. Then when you go to bigger things, right? that's when, and it doesn't, and big is relative, right? So, if you're a PR consultant and you sign an agreement that's going to pay you, $5,000 a month to be a PR consultant, I mean, those things require agreements, right? Those shouldn't be just done on a napkin, right? So, the purpose of having an agreement, you don't have to have an agreement. The purpose of having an agreement is, okay, I'm doing something for you, you're doing something for me. It's beyond the most basic, and people are going to need protection for their stuff, right? So I need protection that I'm going to get paid a certain way. You need a protection, for example, if you're doing PR services for a company, protection like we said before, like the company owns all of it, right? And that's where you want to start to sign basic agreements for the delivery of your product or service. Okay, and those agreements can be relatively basic. Right? Here's what we're going to do for you, or the product we're going to provide. Here's what you're going to pay us and how you're going to pay us, and then a bunch of the legal mumbo jumbo around confidentiality, who owns what happens if if people sue each other, that type of stuff. Okay. The one thing I would say to consider when you're signing these types of agreements, and this doesn't only apply to customer agreements, this also applies to employee agreements and vendor agreements, is to put in there an arbitration clause. And an arbitration clause basically says is that if there's a dispute, the dispute will be handled by arbitration and not by going to court. Okay, and one of the reasons that's important is because any type of law case is expensive. Even if it's the simplest case, even if you have the best case in the world, it's still expensive because you got to go through the whole process. Arbitration is much, much, much less expensive. There's a whole arbitration process that you can start. It's relatively inexpensive. And if you put in there that the arbitration is binding, then both parties agree that it's going to go to arbitration, and it's much better as an early stage company to deal with that if, God forbid, you have to get into dispute about something. Okay. When it comes to customer agreements, I think the legal part is part of it, but don't forget the business part. I know this session is about preventing yourself from litigation, but it's also about setting up these legal agreements in a way that are most beneficial for you. And a lot of times that relates to payment, right? Bigger companies, especially if you're working with bigger companies are notorious for, you provide all the service and we're going to pay you 6 months later. And it's perfectly reasonable to be like, listen, we're a smaller company, we want it. And so that might mean you say, okay, we're going to bill you the day we sign the contract. Let's say you sign a 12-month contract to do PR for whatever per month. You might say, we're going to bill you upfront for the first 3 months, right? And then you'll pay us every 30 days. It's worth having a little bit of a negotiation to try to pull the money up as much as possible, so that you're not in the case where many people are, of saying that, you have to wait and wait and wait and wait. Just so you know, large companies will always say to you, that's not the way they do it. Your business people can push a large company to change that. They can't change it 100%, but they can change it. If they want your product or service, they can always be more flexible than we can only pay you in 90 days and our systems never work any other way, which is just not the way it actually works.
Right, and that's really important to know, especially for small businesses who are always trying to find ways to get paid right quicker. So you have a little bit of that, at least influential leverage is good. So.
Yeah, and even when you bill, right? If somebody says, well, we're not going to pay you any quicker than 45 days, and you're like, great, we're going to bill you on the first of the month for what we provide you over the course of that month. And they'll be like, well, you have to bill us at the end of the month. You're like, wait a minute, you've told us you're not going to bill us, you're not going to pay us for 45 days. So if I bill you on day one and we provide the service for 30 days, then why can't you pay me 45 days after I bill you? And they'll be like, well, we don't do it. And you're like, well, what if the services weren't provided right? You're like, well, there's other provisions for that. If the services weren't provided right, then you always have the ability to not pay us. It has nothing to do with it. So there's just a little bit of a dance around getting paid, which is, and again, this is about getting in trouble, right? Because how many times do big companies, drag and drag and drag? And for somebody that has 10 clients and has a couple $100,000 business, this is all meaningful. So work a little harder, take a little risk up front to push your clients about paying you faster, billing up front, right? Billing for, so let's say you do a consulting project or you do technology development, right? Or you should say, okay, I'm going to bill you for the first third of the project day one, right? Fight a little bit for that. And if it ends up being maybe not a third of the project, maybe you get some of it up front. There's an imbalance between working for larger companies and smaller companies that a lot of times this stuff can, be meaningful into the future. Okay. Let me stop for a second. I've been rambling on. See if anybody has any questions or circumstances that they'd like to discuss.
Yeah, for everybody on the call, please feel free to chime in or any questions or any experiences that you have had that might be interesting to share with the group.
I have a okay, so I haven't officially started providing my services. However, I have a prospect who's interested, and I just want to know, when is a good time? Well, do I automatically start with the agreements with the prospect, or does this come along the line?
Gotcha.
Somewhere along the line.
Hi, Natalie. How are you?
I'm good. How are you?
Good. Where are you based?
In New Jersey.
We're in New Jersey.
Orange.
Gotcha.
Okay.
Know it well. Whitney Houston territory, right?
Yes.
What type of business do you have?
Career advising.
Oh, gotcha. I think that the most important thing is the business side, and if the prospect gets to the point where you come up with what the deal is, right? Is all this career advising provided for an individual, or is it for organizations?
For organizations.
Yeah. So I think that with an organization, if it's a meaningful amount of money, then, listen, sometimes you don't, for this type of stuff, as long as it's well defined enough, you can just send them an invoice. Like, you don't necessarily need an agreement. Sometimes it's worth going through that. Is this kind of a big opportunity for you? Really basic? Like, where is it in terms of size?
Okay, so we're discussing how many, we're discussing that right now.
Yep.
Okay, so being that I'm only one person for right now, it's going to be small. However, I do plan to scale it.
Well, let me ask you a question about that. Is the reason why the contract's small because it's limited? You're limited because it's only you? Like, would they do more if there were 10 U's?
Yes.
Okay. So you should think about that, right? So you should go to them and again, we'd like to know more, but you should go to them and say, I can come to the table. I assume that you have contacts and relationships, and you should think about, okay, is there a way that we could serve this broader for you? And then, be entrepreneurial and try to figure out who are the other resources that you could bring to the table that would be, they're not going to be you, but if you have an opportunity that says, oh, listen, I could do it for 5 people, but I would do it for 50 people if you had the resources, go figure it out.
Okay, so so now I can see, in that case, being that it would be more than me, but on my team, where I would need like the non-compete agreement, or like earlier on, like right away, right?
Yeah, listen, I don't think the non-compete is that like, it's not, sometimes we talk about the legal issues, like these are like the most important thing. The most important thing here is, can you strike a business deal that says, they're going to pay you X to provide career counseling services for, Y number of people. That's the first thing. And that could be done just by invoice, or it could be done by virtue of an agreement with them. The non-compete and all that other stuff is just some stuff you can weave in, but it seems like that if somebody's willing to do more with you, as long as you felt you could bring credible people to the table to help, that you could train, those are good problems to have. And obviously you want to credibly deliver the service, but I think you should also try to figure out a way to do that.
Okay, sounds good. Thanks so much.
Okay, and then the agreement that you sign can be relatively basic. So what I would say is this: get the deal done first, figure out what the economics in the deal is first, right? And then when they say we're ready to go, then you can put together an agreement that memorializes what you're doing.
Okay, my last question was would be, okay, so which agreements would you like recommend in this?
This is just like a basic, like consulting agreement where you're basically providing them a certain type of service, right? Which says, we're gonna provide career counseling. We can connect with you offline. It's a pretty straightforward agreement. Just so I'm clear, the non-compete is just one part of an agreement like this, right? And for a thing like this, it's pretty minor, right? So it's more about the basic services agreement, which can be done through a basic consulting agreement.
Okay, sounds good. Thank you.
Of course. That leads me to kind of one other connected point is that, when you're going to sign a deal with a company, a lot of times it's worth it to invest a little bit of time in getting your basic agreement that you use set, right? Why is that? Because when a customer says go, yes, we want to do this, and you've decided you need an agreement, you don't want to be scrambling around for the next week and giving them something that isn't well thought out. You want to have a standard agreement that describes your products and services, right? That you can squirt out pretty easily and send over to them. Some companies may say, we have a standard agreement that we like to use. And in many cases, it's a little bit of a double-edged sword. Number one, their standard agreement is vetted. They're used to it. They use it all the time. So in that sense, it's easier for them to do. It's also much worse for you. It's set up to be much more pro them. So you should ask them, hey, would you like to use your agreement or ours? And you have to try to strike a balance. I know when we did work with health plans, we said to them, let's use yours, because it was going to be hard to get a new different agreement signed. But when they did use theirs, we just negotiated it pretty extensively.
Okay, that's perfect. Thank you.
Okay, cool. And that's for everybody, just anytime you're dealing with a bigger company. But if your business is getting some momentum, you want to be able, everybody knows here, like the first time you're asked to do something and you kind of get off the phone and you go, oh man, I don't have that. You have to scramble around and do it. And that's fine. It's you don't have to do everything up front, but you want the customer buying process to be as easy as possible, right? Yep, I want to use you. How go, right? And a lot of times that's the impetus for going and getting your basic agreement done and stuff like that. So hopefully that's helpful. Okay.
Yes, very helpful.
Any other questions?
Hey, Michael, this is Nicole Hawthorne. Can you hear me okay?
I can. How you doing, Nicole?
I'm doing all right. I'm so excited to be on this call. You're amazing. So thank you so much for your time.
I'll give you the $50. I promised to say that, so I appreciate it.
Here's my question. So I have a startup with my 4-year-old daughter. Yes, I said 4-year-old. And we sell handmade heirloom dolls of diversity. So it's really amazing. We picked up some great steam, and we're a part of Amazon Black Founders Accelerator. So our dolls will be on Amazon Q4 of this year for the holiday season. My concern is, as we scale and start putting them on Amazon, I want to make sure that everything is safe. So those terms and conditions that you discussed, I'm wondering, is there a way to make sure, even though we're selling on Amazon's platform, that the terms and conditions on our website also, translates over to that channel?
Yeah, Amazon is just one channel of many, right? So whenever you're selling products and services, the terms and conditions of your products and services should always apply, right? So I would imagine in Amazon or in any platform, there's a place for you to put your standard terms and conditions. And those terms and conditions should be the same ones, regardless of the channel that people are buying from. Now, that being said, Amazon has its own terms and conditions, right? That they probably make you subject to, right? As well as customers subject to. But I would imagine in most platforms, no different than you put in a description of the product and a picture of the product and the price of the product and shipping, you should be able to put in terms and conditions there as well.
Okay, thank you. Because that's one of the things that I'm really concerned about. And the second is because, you know, we're small and we're just starting, I'm wondering, should we patent our doll pattern? Because what I've been noticing that happens on Amazon is once you get a little steam, there's copycats that pop up and they do exactly what you do, but for cheaper, right? So my concern is, like, should I be looking into that as well, or is it too premature to start kind of battling the copycats?
Great question. This happens all over the place. So a couple of different things. Number one, it's really, really hard if you think about like nail polish and cosmetic. I mean, there's so many cases of, you know, people knocking off a brand and being done, you know, overseas in different places and cheaper and stuff like that. So in an ideal world, you could go get a patent but it's incredibly difficult to enforce, right? And it's really hard to, it takes time and effort to do it. Now, if you think about what I said before about, you know, people working through Upwork and that you own all the stuff. Now, I said you should get those provisions in there, even though they might be hard to enforce. The difficulty here, Nicole and everybody, is that to put a patent in place costs a lot of money. It's nothing to add another provision to an agreement, but to actually try to go get a patent is hard. What I would try to do now, a trademark is different. A trademark, trademarking a name is literally, in the hands of the right person, 15 minutes and a $350 registration fee at the U.S. Patent and Trademark Office, right?
Okay.
By going online. So if your dolls and your designs have a name that's unique, you absolutely should go get a trademark.
Okay. That was my next question. Look at you already reading my mind.
Yeah, so that's and
Awesome.
connect with us offline, because it's not a particularly, you know, it's a really simple process if you know what you're doing.
Okay.
But I think more so than anything, to your point, even when you have patents and even when you have trademarks a little less because a name's name, like Lonely Entrepreneur, right? Like we own the trademark to Lonely Entrepreneur. It would be hard for anybody else to do anything. So those become meaningful. What I would say is that what you're trying to do, because you may be copied, what you're trying to do is to build equity in that name, that those things are like your thing is the thing. And of course there'll be knockoffs, but it's not the real thing, right? It's like the Chanel bag is either the Chanel bag or it's not, right?
Exactly. Yep.
Right. So it's part of your messaging and part of your go-to-market strategy should really be around, you know, how you are thinking about portraying the brand as, you know, this kind of unique instance, if you will.
Absolutely. Thank you so much. I really appreciate that.
You got it. You know, everybody, this kind of goes back to what I was saying about the beginning when I was kind of like kidding, you know, joking about the legal profession. As you can tell, a lot of these things are business things. They're not legal things. There are things that from a pure legal perspective, you know, Nicole, take your example. A lawyer might say to you, yeah, you should go get a patent. You should go get a trademark. And from a pure legal perspective, maybe, but sometimes there's things that aren't worth it. You know, founders agreement, right? Pretty worth it, right? Because you want to make sure everything's lined up. And so, you know, there's judgment that has to be used along the way. And when you do talk to lawyers, make sure you talk to lawyers. And again, we're happy to help. When you do talk to lawyers, make sure you talk to lawyers that are used to operating in the early stage company space, right? Because a lot of times the bigger companies and bigger company lawyers don't understand that there isn't some pot of money that's sitting on the side for lawyers, right? That pot of money is supposed to be used for sales and marketing and all the other stuff. And every dollar you spend there is something that's just kind of a a necessary evil. Now, that being said, in your case, Nicole, going and file, like a lot of times people don't understand two things about trademarks. One is you get rights in a name, for example, even if you never file for a trademark with the United States Patent and Trademark Office. So if somebody comes up with a name and you start to use it, right? At the moment you start to use it, you can put the little TM or SM for trademark or service mark next to it to try to say that's mine, okay? Now, that can be challenged, right? But once you start using something, you start to get equity in it. Now, the reason why you file for a federal trademark is because it's much more evidence of it. And when you do file for a federal trademark, there's a process where notifications go out and people can challenge it and say, well, wait a minute, I was using it earlier. But a lot of times people don't understand, you don't have to have a trademark to get rights in a name. It's just more evidence of that trademark. And the minute you start using it, you start to get rights. So the real question would be, let's say that, Nicole, you had your name and somebody else had your name and they were using it 4 months later, right? As long as you were using it earlier, you should have rights to that name. Okay, so I'm not saying you shouldn't file for trademarks, but what you should be doing, if you have something you think is unique, you should there's nothing wrong with putting a little TM and a little SM next to it, right? Showing the world that this is actually your mark. Now, that could be challenged down the line because if you're somebody halfway across the world that did it 6 months before you. Okay, but these are called, not to get into the legal stuff, this is called common law trademark rights, right? You get it just by using it. Obviously, getting a federally registered trademark with the PTO is memorializes that in a much more deliberate way. Okay, things you would never learn unless you paid a lot for law school.
Yeah, no, that was so helpful. Thank you so much, because I'm in the process of actually trying to file for a trademark. And it's not like wicked expensive, but it's a little bit out, for my small business. So I'm just making sure that I can do what I need to do. So that was super helpful. Thank you so much.
Yeah, and Nicole, is your product already out there?
It is, yeah. We've been selling for about several months now. So we're just now picking up steam, and that's why we're going to be offering them on Amazon now.
Gotcha. The other thing people should realize about trademarks is there's something called an intent to use. So let's say in the middle of the night, you come up with this brilliant name and you haven't started the business yet, but you intend to. One of the categories you can pick when you file for a trademark is this intent to use, where you have to, within, I believe it's 6 months, actually use it. So if you come up with something you think is really cool and you're willing to spend the $350 to do it, you can go on there and file an intent to use trademark. And the only thing that requires, now it could be challenged just like anything other trademark, but what that requires is for you to you have to file something with them showing that you've actually used it within, I believe it might be 3 months, but I think it's 6 months after you file the intent to use. Cool. Listen, obviously, when you go into other areas of business like raising money and others, things get more complicated when it comes to protecting yourselves. But I hope, and everybody's in early stage companies are obviously, striking a balance with where they spend their money. And a lot of times you can get help from lawyers that are willing to do stuff for you for free. Friends and other people that this type of stuff, like forming companies and helping you get and show like this stuff's not that hard for people, that you can do that. And there's lots of networks of folks. In fact, in the not too distant future, Lonely Entrepreneur is going to be bringing to the table a series of free resources in a bunch of these different areas to help people with this stuff. So stay tuned. Still a couple months off, but we'll be trying to help. Obviously we're here to help, but try to provide a little bit more resources for folks.
All right. Great insights. And I know we have a couple of minutes left, so just want to open it up to anybody for any comments or questions.
I just wanted to say really quick, I checked out Nicole's website in just 2 seconds. Mm-hmm. Amazing, brought tears to my eyes. I
Oh,
I
thank you
would
so much.
suggest you post the link to your website so everybody can see it. Amazing concept, beautiful dolls, and good
Thank
luck.
you. I will. I will. Thank you so much.
And I just want to add that Nicole is bringing in, you know, maybe the youngest of our entrepreneurs yet, her 4-year-old daughter.
Beautiful.
Yes, I tell her all the time because she's my co-founder that you're probably like the youngest member of all of the groups that I'm a part of, and all of the grants that we've won so far. She's been the youngest co-founder. So we're setting some really high bars for all the young kids in preschool with her.
Well, I think, Nicole, you know, it would be really fun if you're open to it. We would love to, let's do a little interview with you and your daughter, and it would be a really fun thing for us all to do together.
Definitely.
See if we can get you guys.
She would love that. We're in Charlotte, North Carolina, and we just came from an interview with the Charlotte Post. So she would absolutely love that. Thanks, Michael. We'd love to be a part of that.
Terrific. Well, thank you, everybody, as always, for taking time out of your busy day. We'll follow up with anything that people need. As Victoria said, if you have some time it takes about 10 minutes to complete that survey. You know, we really look at it closely to try to figure out what we can do better. A lot of great suggestions come out of that, and just trying to figure out better ways to do it. So thank you, as always, for everybody's time, and we will see you here next week.
Thank you, everybody, and hope you have a great weekend. Looking forward to seeing you.
Have a good one. Thanks, everyone.
Thank you.
Bye, and thank you.
Bye-bye.
Bye. Thank you.